into the courtroom? All right, I am beginning the recording and letting IT know we can begin to broadcast. Oyez, oyez, oyez. All persons having business before the Honorable the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and its Honorable Court. Case number 20-1492, City of Oberlin, Ohio, petitioner versus Federal Energy Regulatory Commission. Ms. Elephant for the petitioner, Ms. Benta for the respondent, Mr. Super for the intervener.
Good morning, counsel.
Good morning, Your Honor. Shall I proceed?
Please do.
May it please the court. This is the City of Oberlin, Ohio's second time before this court challenging the unlawfulness of the Commission's reliance on foreign contracts to justify its approval of the unneeded and undersubscribed Nexus pipeline, which took city property in eminent domain. In Oberlin 1, this court reaffirmed that in contrast to Section 7, there's no eminent domain authority for exports under Section 3. And for that reason, this court remanded the case to the Commission to explain why it is lawful under Section 3 of the Gas Act and the Takings Clause of the United States Constitution for the Commission to credit exports towards a finding of need under Section 7. On remand, the Commission recycled many of the arguments that this court already found insufficient in Oberlin 1, and further advanced a theory of commingling, which, if taken to its logical conclusion, would transform any export pipeline into an interstate gas pipeline. Without exports, this 40%, there's no evidence in the record to show that this 40% subscribed pipeline can be sustained, particularly in light of FERC's dubious and black box decision analysis of the availability of capacity on neighboring pipelines. Let me turn first to the Commission's justification of its reliance on Section 3 exports, with the reminder that FERC's explanation is not entitled to deference to the extent that its explanations implicate constitutional rights. So FERC's first reason for why it relied on Section 7 is essentially one that was already foreclosed by this court in Oberlin in footnote 2. The Commission says that there's a presumption of public interest findings for exports to free trade nations under Section 3, and that's sufficient to satisfy the more robust standard of Section 7. And the Commission goes on to say it differently. Instead of saying that exports and imports are the same, it says that it can treat precedent agreements for exports basically identically to precedent agreements for domestic use. So that's the same way. That's a different way of saying the same thing, that it's going to credit exports the same way as it would treat domestic use. And again, that's something that the Oberlin court reminded in footnote 2. It said it's not sufficient to consider this public interest standard as enough to satisfy the need under Section 7, because Section 7 includes eminent domain. Now, that wasn't FERC's only explanation. It also tried to highlight some of the domestic benefits associated with exports. So, for example, the Commission talked about how this pipeline was creating this byway between the US and Canada, and gas would flow back and forth, except there's no indication in the record that this pipeline was anything but a one-way ticket for 260,000 decatherms of gas to go to Ontario and stay there. And in fact, the Commission, in its own remand order, paragraph 20, page joint appendix at 377, admits that many of these facts are beyond the scope of the record.
Well, let's be clear. The record is clear, is it not, that this gas will pass interstate, all right, at some point. Is that not correct?
That is correct, Your Honor.
All right, so that's where the Commission begins, it seems to me. And then it says that the fact that some of the gas will proceed as an export is no bar, and it cites some precedent, et cetera. And I don't see where you have indicated either that those factual findings are clearly erroneous or that the Commission erred as a matter of law.
So there are two issues, Your Honor. The Oberlin court acknowledged that if a pipeline can stand independent of exports, it can be certificated under Section 7.
Well, I wonder in remand whether or not the court went quite as far as you are suggesting in Oberlin 1. It clearly wanted an explanation, but I didn't understand it, and maybe I'm incorrect, and certainly my colleagues can correct me, in saying that the commission didn't say what you have purported it said, namely that the export aspect of this doomed any Section 7 finding.
So, Your Honor, I'm quite certain you're not incorrect in your memory of City of Oberlin. However, in Section 3 of City of Oberlin, this court said that it disagreed that it can never lawfully issue a Section 7 pipeline if exports are included. However, there needs to be a showing of public convenience and necessity independent of precedent agreements for export. And so our position here is that independent of those export agreements, you've only got a pipeline that's 40% subscribed, and that's what the problem is. FERC never justified that 40%.
Well, I don't quite understand that because, first of all, 40%, it has these 8 agreements. Secondly, it has this interstate traffic, which the commission found would provide alternative avenues, et cetera, for shippers interstate. In other words, don't you have to convince us that by relying at all on exports, the commission was somehow wrong as a matter of law or clearly erroneous in finding that the interstate aspects and what it found were benefits independent of exports was simply insufficient?
So the benefits that the commission found, again, are not linked to this particular project. This project was designed to provide a seamless path of gas, some of it interstate, and then 260 decatherms to Canada. There's no indication that it was going to flow back and forth or help balance the system or do anything.
Well, but my question is, was that necessary as a matter of law? And I don't see you citing as something that says it is.
Well, it was necessary for the commission to justify why it could rely on exports towards a finding of need. So the commission gave 3 reasons. It said it gave this equivalency reason between Section 3 and Section 7, already foreclosed by footnote 2 in Oberlin. Second reason it gave is that there are domestic benefits associated with this gas. We're arguing there weren't, that 40% of the pipeline is indisputably domestic, but the export portion doesn't have any domestic benefits. That's our second argument. Our third argument is that exports aren't justified because you can't, and what FERC says is that this really wasn't an export pipeline at all. It's interstate because the gas is all commingled. And that commingling theory has never been applied when you're dealing with an interstate pipeline in foreign commerce. That's only for interstate and intrastate. And in fact, commingling for interstate and foreign commerce is foreclosed by Section 717A7 of the Natural Gas Act, which says that gas that crosses state lines is an interstate commerce only so long as that commerce takes place in the United States. So the gas going to Canada is commerce that doesn't take place in the United States, and it can't be commingled. So those are the 3 reasons we gave for why FERC's analysis of why it was able to rely on export pipelines is incorrect. Once you take out the exports, there's no support for just the 40%. As Your Honor points out, precedent agreements do carry some weight, but they're not the only solution. If you have a precedent agreement, even for millions and millions of decatherms of gas, but you can show that a pipeline next door can accommodate all that gas, there's no need to build a new pipeline. In this situation, the commission says there's no available capacity on neighboring pipelines to absorb the gas. It says it relied on publicly available information, but we don't know which pipelines it examined, what time frame it looked at, whether it assumed that this gas was all going to travel together or could be split split up to different tracks. It basically just substituted a number for an analysis it had done before. And the Oberlin court also found that fact very significant. It found that if the pipeline was 59% subscribed, that gas couldn't be accommodated on other lines. But that's not necessarily true when there's a lower amount of gas in the pipeline. And finally, the commission also relied on these sort of generic arguments for why the pipeline is needed. It'll open up bottlenecks, unbottleneck the infrastructure, allow for development of other gas. And as Commissioner Glick pointed out, those are generic benefits that could be used to justify any pipeline.
Can you point us to a case in which we've held that a pipeline didn't serve the public convenience and necessity that was, subscribed at a 40% rate and that had these benefits that FERC has asserted?
So I can't cite the court to a case that affirmed a pipeline that was 40% subscribed, because as we pointed out in our rehearing petition at footnote 18, and also argued in our brief, it's very rare for a 40% subscribed pipeline to even go forward. The Kinder Morgan pipeline, for example, that we discussed in our brief, didn't go forward because it didn't have enough capacity. Most of the cases this court sees are 90% or 100% subscribed, cases like Allegheny Voices, EDF versus FERC. And EDF versus FERC, again, as your honors are aware, isn't a similar situation here. We're not arguing that there was self-dealing or even that there was any self-dealing here, but EDF does remind us that there's a need for a cautious and thorough analysis of need under Section 7 because eminent domain rights are implicated. That's in EDF 2F4 at page 961. And so I think the reason these cases have never come before the court is because at least prior to this case, there was a recognition that you had to be able to show some degree of need, and a 40% subscribed pipeline wasn't going to cut it. I see that I am running into my rebuttal time, but I'm happy to answer more questions.
All right, counsel for the commission.
Good morning. I'm Carol Banta for the commission. I don't know whether the court would prefer that I start with the export issue or the alternative finding at the 42%, but one common thread between both is that when the commission does a Section 7 analysis, and this, make no mistake, is an interstate pipeline that goes from Ohio to Ypsilanti, Michigan. It does not approach or cross the border. And so the commission, as it must, looked at this as a Section 7 pipeline. And I believe that's consistent with City of Oberlin said, if you're going to look at this Section 7 pipeline, you have to explain why you can count the precedent agreements that are for export. But when the commission is doing a Section 7 analysis, as it explained in the first case, and the commission or the court upheld the commission on the vast majority of issues, and in particular regarding how it conducted its Section 7 analysis until we got to the export question. The court said that the commission engaged in its broad-ranging inquiry reasonably. It's a flexible inquiry under the commission's policy statement from 1999 that doesn't just look at precedent agreements. It does look at other benefits, and it applies what the commission calls a sliding scale, which means, and there is an environmental aspect as well, which is not at issue in this case, but before you even get to the environmental analysis, the commission looks at the market need, usually by way of precedent agreements, the other benefits that the pipeline may provide, and weighs it against the adverse impacts, principally among those adverse impacts being eminent domain. Now, in this case, in the original analysis, the commission made the point that, yes, we had 59% subscription in the original analysis, 42% in the alternative analysis done on remand. We also have other benefits, and we're weighing
What do you mean by the other benefits?
Well, in specific to this case, besides some of the benefits that might be more general to what an interstate pipeline provides, here in particular is the takeaway capacity for Appalachian Basin production, which has been constrained. The Utica and Marcellus Shale production region produces a lot of what could be economical gas, but it isn't where it needs to be in the markets that need more access to economic gas, such as the commission noted in the Midwest, by carrying this from Ohio, where it actually picks it up from Pennsylvania and West Virginia into Ohio. The pipeline runs from Ohio to Michigan, and it can serve customers in Michigan. It can connect to other pipelines that would take it to Illinois and the upper Midwest, and give more access to a production area that has experienced constraints in that there's not enough takeaway capacity.
Does the record support the proposition that it couldn't be taken away without this pipeline?
I don't know that it couldn't be taken away without it, but there was evidence in the record of the besides the commission's just expertise under knowing what's going on in the markets, that there has been bottlenecked capacity from the Appalachian Basin. I know that Nexus had some evidence of that in its application. It was, I believe I have cites to that aren't in our joint appendix, I think, because they were an attachment to the application, but they were in the original case to Nexus's resource report. But the commission also was aware of that, and the commission cited it in the certificate order, specifically in, okay, so the first JA from the previous case, it's at JA 309-310. I know you don't have that, but we could submit that if the court doesn't have access to it. But the commission also cited it in its certificate and remand orders, I believe. So there was evidence in the record, which again, as to the parts of the commission's sliding scale balancing analysis, the Oberlin 1 court affirmed that as having been done right. The only question was about the precedent agreements that were being counted.
Ms. Banta, as to FERC's alternative ground for upholding the certificate, the commission did not consider why a smaller pipeline would not suffice to serve the domestic precedent agreements only. And since in your alternative reasoning, FERC was considering only the domestic precedent agreements, is it unreasonable for the commission not to have considered more specifically an analysis of a smaller pipeline? Actually,
Your Honor, it did the same analysis it had done with the 59%. It did again in this order, and I would point in particular, I know footnote 73 on JA 383 gets into some of this. In the original analysis, because when the original environmental impact statement had been done, that includes a lot of the alternative analyses, it was done based on 1.5 million decatherms per day. So for the certificate order, the commission redid parts of that analysis to account for the fact that at that time, they only had 885,000 decatherms per day subscribed. So the commission looked at the downsizing issue in the certificate and rehearing orders, and it repeats it here. The difference between the 885, you're still doing the same pipeline route, you're still taking the same property. The difference would essentially—
Would it be as large a taking? That is a question that I have, is would there be as much of a taking if you were using a smaller diameter pipeline?
I believe that I wish I had a citation for this, and I can provide it later if the court wants it, but there was an analysis somewhere in the original record. If it's not in the orders, it might be the environmental impact statement. I think it's in the certificate order, that the difference was maybe along the lines of 20 acres. The difference would largely be compressor stations. It wouldn't be the land taken for the pipeline, but it would be how many compressor stations and whether you could eliminate any of the compressor stations. And there might be some acreage around a compressor station that you could eliminate. That would be the effect of downsizing the pipeline. And the commission also pointed out that sometimes it doesn't make sense to downsize it if you might have to build a bigger pipeline in the future to accommodate demand in the future. So again, going to the sliding scale, if it had made a huge difference in the acreage or a large difference in the eminent domain, and they got 93% of the land required for this without exercising eminent domain, which the commission pointed out in the first case is quite high for one of these cases. So in the sliding scale of the amount of benefits, including not just the precedent agreements, but the other benefits like the takeaway capacity, balanced against the adverse impacts, the commission found that the balance made sense in this case. It might not in another case, in a case that required more like 70% or 30% eminent domain. I don't know if the analysis would be the same. It's very fact-based in each case. One other thing I would say with regard to the commission did look at the difference between the 42. The commission staff in the environmental impact statements often makes this calculation looking at the publicly available capacity information on the websites for pipelines in the area. Originally, it did it to see if there was capacity for 1.5 anywhere, and it said no. It then redid the same analysis in the first round at 885 and found there was not sufficient capacity available on other pipelines in the area, and did it again for 625 for the remand. This is something commission staff does pretty routinely in putting together environmental impact statements. They do it using the same public websites that anyone can access to look at different pipelines in the area. I think they identified which pipelines they were in the original environmental impact statement. I'm sorry. Yes.
Those websites have fairly detailed information about pipeline capacity.
I'm not familiar with them myself because we have expert staff that does that work, but I believe they do have, and I don't know whether Mr. Super would have some knowledge of this when it's his time, but they are required, I think, to put certain information about the capacity that's under contract versus available. And I know that I did check FERC staff isn't using some kind of proprietary information that we have access to. It is publicly available information that the pipelines have on their websites, potentially for other customers, I guess. I see that I'm out of time. I did want to address the exports, especially if the court has any particular questions about that. But I want to emphasize the commission did not rely on equivalency between Section 3 and Section 7. In fact, it expressly disavowed that in a footnote, I believe. But what the commission did is it said, we're looking always for Section 7, we're looking at domestic public benefits. And the commission, in its analysis, found that exports with free trade countries, specifically Canada here, and in this pipeline particularly, have benefits for the US public. We're not talking about the benefits to Canadian customers. We're talking about the benefits the commission found. And one, I'll say in paragraph 20, and when the commission's on JA 377, when the commission says beyond the facts of the proceeding, it doesn't mean outside the facts of this proceeding. It means more generally including this proceeding. And it talks about the benefit of free trade in gas imports and exports for US customers. And that goes back to the discussion on the previous page about the Dawn Hub in particular, that when gas goes to the Dawn Hub, which is the second largest trading hub for natural gas in North America, a lot of it ends up back in the United States. Now, we don't know when a particular particle of gas crosses the border, does that one end up in New England or New York? We might not know about that particle, but we know about the impact of free
You have to
trade.
show something specific to this pipeline project, though, and not just the generic economic theory of benefit to the U.S. public.
Well, I think, yes, but it's also
rather like your claim about, or I don't know, claims are right word, the language about jobs being generated. That's always true in a construction project. That's not something that I think you'd be able to weigh. And I'm not sure that what you're saying now is sufficiently specific to this pipeline to be appropriate to weigh it in the sliding scale analysis.
Well, this is where the commission is looking at, is it lawful for us to even consider precedent agreements for gas that may ultimately be exported? And
well, it's
Congress,
not maybe.
Yeah.
This is a commitment for 17% of what your capacity would be destined for export, wouldn't it?
Well, that's not exactly the case, because that's the amount they've contracted that they could export.
Yeah.
We pointed out in the first case, and I didn't want to belabor it.
But you're
because
relying on that amount as being a basis for a convenience and necessity. And if that's going in export, it really can't be relied on, can it?
Well, we know we don't know that gas doesn't always go to Canada. We were assuming for purposes of this discussion that it is. As a matter of fact, they can sell it off at Ypsilanti, or they can send it to the Don Hub and send it back into the United States. But the commission was looking at the benefits. When we're talking about the lawfulness of considering exports at all, the commission was looking at whether it's reasonable for us, the commission, to find domestic benefit in the free flow of trade, in particular here with Canada, not just because it's in Section 3 and Congress said something about it in Section 3, as well as in NAFTA and the USMCA, but the commission itself is making the finding that it does benefit US customers. In addition to the other benefits, this particular pipeline, like the Appalachian Basin takeaway capacity. And so the commission is just asking the question, is it lawful and reasonable for us to include these two precedent agreements with the other 6 in assessing this particular pipeline? When it goes to lawfulness, at any pipeline, the Section 7 analysis of any pipeline has to stand or fall on the merits of that factual analysis. The question here is, are we going to preclude the commission from even considering the domestic benefits of exports as a matter of law? Or are we going to consider in a particular case that the commission may find benefits in those agreements that it makes sense to include them in the mix, that we then apply the sliding scale analysis under the policy statement to? So that's why the commission made the case that not only is it in the domestic public interest to include these agreements, but that the rest of the analysis, this pipeline had already passed the commission's analysis and the court's review at the 59%, with the weighing of the benefits versus the adverse impacts. It had already passed that in Oberlin 1. The question is, are we doing that with the 59% because including those agreements is lawful, or are we doing it the 42% because the commission has to just pretend that exports have no domestic public interests, even though it knows and has found that they do? So I think that's how the commission was looking at the question.
All right.
Thank you.
Why don't we hear from Intervenor?
Thank you, Your Honor. David Super on behalf of Nexus. May it please the court. Judge Sentelle, I think I may start by answering one of your questions about evidence for the presence of a bottleneck for takeaway capacity out of the Appalachian Basin. And the commission did cite in the rehearing order to a resource report that was provided by Nexus that provided evidence of that. And unfortunately, it's not in the joint appendix of this appeal, but it was in the joint appendix of the last appeal. And the information is at JA 311. I'm afraid that's the best I can do right now for that one, giving you a citation. I think it's important, though, as Ms. Banta was saying, to focus. I mean, while the 6 precedent agreements for domestic deliveries representing 42% of capacity is important and can be relied upon by the commission as evidence of need, this case involves a wide variety of evidence of public need that the commission relied upon. And as Ms. Banta mentioned, relieving the takeaway constraints out of the Appalachian Basin was one of those points, but the commission also found that the pipeline would provide Northern Illinois and other Midwestern markets with access to additional supplies of gas. And those are tangible public benefits really at both ends of the pipeline, alleviating a bottleneck on one end and enhancing markets in the Midwest on another. And Judge Rogers, I believe this is the evidence of public need that you were referring to in your concurrence in the first Oberlin opinion, where you said, here the commission's findings regarding the need for and the nature of the Nexus pipeline are supported by substantial evidence in the record considered as a whole. And I think it's important to emphasize that then Commissioner, now Chairman Glick, praised the fact that the commission was looking at all of the evidence and taking a holistic approach to looking at a wide variety of evidence of public need and not just looking at precedent agreements. And just 7 months ago, in the Environmental Defense Fund case, this court actually pointed to the Nexus project as being supported by multiple market studies, and the court described the evidence of the market demand in that case as much stronger. It's much stronger in this case than it was in that case. So yes, the 6 domestic precedent agreements are significant evidence of need, and the commission's reliance on those agreements deserves deference. But here, the Nexus project is supported by additional evidence of need, on which the commission relied to find that the project was in the public convenience and necessity. And that's even without considering the 2 precedent agreements that contemplate deliveries of gas to Canada. So that's an alternative determination that this court can rely upon to approve the Nexus project. I see that my time is up. If you have any questions, I'm happy to answer them.
Hearing none, we'll hear from counsel for City of Oberlin.
I'd like to respond to 2 points, Your Honor. First, with regard to the alternative analysis, yes, there are 6 precedent agreements here, but we still can't tell from the record whether that gas can be transported on available capacity on neighboring pipelines. We raised that argument in detail on rehearing in the joint appendix at 614. FERC never acted on the rehearing, and they never in their brief cited included any citations to what pipelines they looked at. Just saying that information is in the public record. The public record at FERC, their docket sheet goes back 20 years. Their information on other pipelines is all over the place. We were not able to track down which pipelines FERC examined, what kind of capacity was there, any of their assumptions underlying.
On remand, that the commission identify the specific existing pipelines on which it relied.
I'm sorry, Your Honor, I didn't hear the first part of your question.
Did you raise this question on remand?
Yes, Your Honor, when the case was sent back to FERC.
I know, but my point is the commission said it looked at existing pipelines and determined there was not the capacity that was needed. And you say, but we don't know which other pipelines they looked at. Did you ask them?
Yes, in our rehearing request of the remand order.
I understand that. And when you didn't get what you wanted, did you indicate that so FERC could respond? I mean, raising it now before us isn't the same.
Yes, Your Honor. I guess what I'm saying is we filed a rehearing petition of the FERC order. For the remand order came out, it said we relied on this public information. In our rehearing petition of that remand, which is in joint appendix at JA 614, we said, we can't tell what you looked at. We don't know what assumptions you made. This was a case where FERC didn't issue an order on rehearing. This was one of the Allegheny cases that came straight to the court. And so FERC didn't put anything in it on its brief either. So the record is open there. But yes, we did raise that argument because it's been something that had been nagging at me since Oberlin 1, when Oberlin 1 found that there was no available capacity for the 59%. I thought for sure that when it went back on 40%, that would be addressed. So that's the first point. The second point is we're not suggesting that FERC can never take into account any of the benefits of export pipelines. It can do that, but under Section 3 is the appropriate place for it. If we take FERC's consideration of those benefits of exports to a logical extreme, we're going to be in a situation of granting eminent domain for export pipelines, and that's not appropriate. And in fact, our suggestion for relief here is to remand this case to FERC and to have it issue or consider whether to issue a Section 3 pipeline.
What I'm getting at is I understand your broad general statements, but you don't deny there's this bottleneck. You, like anyone else, can determine what pipelines serve that area. And do they have the capacity? And maybe you don't have all the detail and expertise that FERC does, but this is not as though, what I'm trying to get you to focus on is maybe you didn't get chapter and verse the way you wanted, but it's not as though the commission was relying on pipelines in South America to find there was no capacity. They were looking at this region and what its needs were. And these pipelines are large enough that they can't sort of be overlooked. So if there was any evidence that there was a capacity, availability on existing pipelines. Why couldn't you have raised that before the commission?
Again, we weren't able to track that exact information because we don't
need exact information. What you need is evidence that there's existing capacity. And your proposition is FERC hasn't proved there is none. Well,
Yeah.
where's the evidence that there is any?
Well, it's very difficult to tell from public information. There's not necessarily sites that are easy to go to where you can see what kind of capacity was available, if it was back in 2017 or now. We just weren't able to.
I appreciate that, but I'm trying to understand what it is you wanted FERC to give you specifically when it had these staff reports and they're available to you and anyone else. That's all. I mean,
Yeah.
You're suggesting, as I understand it, that FERC is somehow pulling a fraud on the court. I don't see any evidence of that. And I think at some point there is a burden to say, you can't rely on South American pipelines here. We're talking about a particular region. What's going on in that region?
What we're suggesting, Your Honor, is that the commission relied on information, the source of which they say public information, which can encompass many different things. In City of Williston Gas, the court held that if the commission doesn't specifically identify the source of its information, then its conclusions are impervious to judicial review.
I understand all that, counsel. I'm trying to understand what happened here. We sent it back so all of this could be examined. All right. And I just don't understand why this wasn't all worked out on remand. That's what I'm trying to understand.
Well, as I said, Your Honor, we did raise these issues in our hearing.
I hear you. So I've heard your argument.
Okay, I'm sorry, Your Honor.
No, thank you.
Thank you, Your Honor. If there are no further.
So we just hear from counsel for the commission. I want to get this clear in my own mind. The city has argued, it raised this issue in its remand. It said, we don't know what pipelines you're looking at. What did the commission say?
Well, they raised it on rehearing and the commission did not issue a rehearing order. So we didn't say anything.
All right, they said, look, you say there isn't capacity on existing pipelines. And the commission says, we've looked at existing pipelines and determined that there is no such capacity. What pipeline?
Well, we had done it twice before, and going back to the original environmental impact statement, which I apologize, I don't have it in front of me, although I do recall that I was looking at page 1035. There's a section in the alternatives that says there are, I believe it said 6 pipelines in this same area, which could, in theory, serve the same path, although it would require some laterals and some adjustments and some loops, I believe it said. And that's the initial discussion where the commission looked for 1.5 million, where the commission staff in the environmental impact statement. So I don't know whether there was an attachment somewhere later to the environmental impact statement that identified which 6, but it did say there are X number of pipelines. I'm going by memory. I do believe it was 6 in the area. And we've looked at those and there aren't 1.5 million decatherms available cumulatively. Right. And then so the commission did the same analysis at 885 and again at 625. And it was still looking at pipelines that could theoretically, with some modifications, serve the same path from Ohio to Michigan. Although it did note from the start that they couldn't just pick up the gas and take it. There would be laterals and loops and various kinds of, you couldn't go straight from here to there, but you could maybe get from here to here to here to here to here there. And that's what the commission looked at and said there isn't enough capacity anyway. And it did it at all 3 levels.
So your response is it's in the record and council just needed to look more thoroughly?
That we gave more detail in the original environmental impact statement, which, as you know, is a long process with a lot of parties involved, including Oberlin.
Well, but you've heard counsel for the city. It said we couldn't tell which existing pipelines the commission looked at. And what I hear you saying is, well, it was part of the EIS, the original one, and the revised one, so it was all there.
And it was cited in the certificate order. And I think we didn't, when the case came before this court in the first time, the court did say that the commission had conducted its analysis reasonably and really only had questions about counting the export agreements or whether 42% would be enough. So I think the commission didn't start from zero. It didn't start as though it were a new,
All right, thank you.
Thank you.
All right, anything further my colleagues would want to ask?
No.
Well, we'll take the case under advisement then. Thank you, counsel. So if the clerk would call the next case.
Case number 21-5049, Benoit Brookens appellant versus Larhonda Gamble, President Local 12, AFGE, AFL-CIO et al. And case number 21-7020, Benoit Brookens appellant versus Dino Drudi et al. Mr. Brookens for the appellant Benoit Brookens, Mr. Harris for the appellees Larhonda Gamble and Dino Drudi, Mr. Sereno for the federal appellees.
All right, Mr. Brookens, please proceed.
Mr. Brookens, I think you might be on mute.
Can you hear me now?
Yes, thank you.
Yes. This case is about whether the district court erred, and we have two different cases, in its reading of the statute 29 USC 419-412. And it's cited, fortunately, in the appellee federal's brief at the addendum, page 37. And the operative words are, any person whose rights secured by the provision of this subchapter have been infringed by any violation of this subchapter may bring a civil action in a district court of the United States for such relief, including injunctions as may be appropriate. And with this provision, it started in the election and so the question is Mr. Brookens' voting rights. And the primary action started in the 2018 election for national president at the AFG 2018 convention. And as a consequence of that, two actions which are not related to, they are related, but they're not related. Two candidates who were running. One was the treasurer for AFG. He decided to break ranks with the president and decided to break and run for president himself. And the second one was the president of Local 12, which is headquarters local for local where I was based. And he decided, after he had settled an $8 million class action overtime lawsuit, that he looked like he was going to be a candidate for president for the AFG union. And of course, if you do any kind of class actions and you win or get a settlement, you're going to be telling everybody. So the National Union decided to put Local 12 into trusteeship, and that infringed on my voting rights. As John Lewis says, voting is your primary nonviolent tool. So I filed my own civil action instead of filing under the federal action. I filed in district court saying you're violating my rights by infringing on.
So the district court issued an opinion in which it set forth its analysis, all right, of the statute you were relying on as well as an alternative. And it said you were mistaken, all right, because that statute simply didn't authorize the district court to proceed. as you wished it to. All right? So you have
Yes.
to persuade us that the district court's legal analysis was incorrect. And why do you say it's incorrect?
I think the reason is that I tried to identify cases where the same issue arose with other union participants in this district. In those cases, there were several cases where union persons who were challenge actions to infringing on their rights at the local level or at other council
You
levels.
understand that the binding precedent comes from the circuit and not the district. And we have held, have we
Sorry?
not, that where you have a mixed parent, but a government only affiliate, the affiliate is not within the jurisdiction given the court under the statute. Is that not correct?
No, my understanding is that if the law is the law based on arguments that this court has put out, if you have a subordinate and to a mixed parent, then under several theories, the mixed subordinates are also covered by the federal statute. And
But this is a government only subordinate here, right?
I'm so sorry.
This is a government only subordinate here, right?
Yeah, for Local 12 is only a government subordinate, but if once you look at if there are regulations that say, look, we're changing our strategy, we're changing our theory. Let me just break down the two parts. One, in arguing before the district court, I tried to stick strictly with what this court had to say about this issue and the cases that were relied on by this court in addressing those particular issues. And so it's a two-part approach. So I'm just going to cite to this case because I cannot expect this court really at the trial level to look at any other interpretation other than what this particular court has to say. But at the same time, the other jurisdictions have come to the same conclusion. If you have a mixed parent or a mixed intermediary, they're covered. And I did cite that in talking about my issues with the Dino Drudi case, where you do have other mixed that are involved in the process, and so they would be covered by virtue of the fact that their parent is covered by this particular statute. So and at the same time, you look at the government. The government tried to say, well, the Labor Department has changed. The Labor Department implemented regulations that support position, but they rescinded them. No, they've adopted the rationale for another jurisdiction, saying, look, what we're trying to do is to make sure that these subordinates are included. A union member in a different area be covered by this particular statute and protected by it. And so
I might ask you a question, Mr. Brookens. With respect to your claims against the council officials, do you have an intention to run again for election? Are you interested in again running for an election? Because of course the election that you originally brought the suit for, is no longer one on which we could grant relief. So
I think yes. I'm sorry. Yes. I've been in the union 20 years, and I'm either running for an office or I'm backing somebody who's running. They understand I have a vote. So when you take away my voting rights, I've been on this council for at least 20 years. I've rotated on. There are 3 different councils. I run for office.
And your argument that if you were precluded unlawfully from voting in the vote that's already taken place, that result is invalid. All right? Because your argument is you were entitled to vote and you were denied the right to vote. But I'm back to where Judge Sentelle asked you his question. Now we have this case all right, that the district court relied on Wildberger. And that was decided in 1996. And the district court looked at that and it determined, in light of that, that here's what it had to conclude. And then it cited one of its own opinions because there was a question left open in Wildberger. So you have to persuade us that the district court erred as a matter of law, at least as to the statute under which you were seeking relief. And I
Yes.
haven't heard you do that yet.
I think there are several items. First of all,
Well, let me just point you directly to what I'm concerned about, where the district court says that a government-only local or council is not, quote, engaged in an industry affecting commerce, close quote, and therefore is not a covered, quote, labor organization, close quote. Isn't that correct? And he cites cases from other circuits.
Beside another circuit, I think this is where you have the case of Child versus Bemerton, which is the same. This is where the Labor Department filed action against a intermediary council because
What court
of
is that?
It's another. I think it's Texas. I
Texas
think
what? Texas district.
the circuit court for Texas. In fact, I should cite it on my brief.
That's a
Bremerton.
state court, correct?
No, it's a federal court. It's a district court. Let me
So
look
what-
at.
What
Just
circuit?
one second. Child versus Bremerton.
Yeah,
And I cited on my brief for Gamble on page 3, and I cited on page.
what circuit,
So-
Ms. Brookens?
I'm sorry.
What circuit court of appeals?
I didn't put that. Oh, I didn't put that on my. Let me see. Bremerton is cited. I'm sorry, Ninth Circuit. Ninth Circuit. The Ninth Circuit. It's on page 3 of my brief for Drudi. And so this case, this is Drudi, so, the Ninth Circuit. So this is where the
Well,
Labor Department.
we're not bound by the Ninth Circuit, as you know.
No, that's why. I'm sorry, Your Honor, go ahead.
What the district court did was look at the plain text of the statute, looked at our opinion in Wildberger, looked at what some other circuits had held, and determined that the nature of the entity on which you were focusing was not covered. Period. And the language I read, that under this statutory scheme, government only local or council is not, quote, engaged in an industry affecting commerce, close quote, and therefore is not a labor organization under the statute on which you're relying.
Well, I think that's why the Labor Department, and I've cited their regulations.
Well, the regulations can't go contrary to the plain text of the statute.
Your Honor, the Labor Department has interpreted their regulations consistent with this particular language. The language of the statute we're talking about is Section 412, and it's a broad statute. And the regulations that the Labor Department had promulgated over the last 20 years, whatever it is, they said, no, we're going to adopt the interpretation for the Bremerton case because it better fits with what the statute we're trying to accommodate. I'm not into a debate with the Department of Labor versus the Department, but the issue is that they're affecting my particular voting rights, and so I'm taking action to protect my voting rights. To give me a right to vote the day before the national convention is not helpful. I may want to run. I may want to support somebody. I may want to run. So that infringes on my rights. At the same time that I was elected to the Council 1, so Ms. Gamble was elected to Council 1. She's a delegate. I'm a delegate. I'm on the council for a couple of years. I decide I want to run for president.
So the district court notes that you do cite a fact sheet posted on the Department of Labor website about whether a local union or a parent body represents any private sector employees, that your complaint is covered by the Lambda. And the district court says, well, whatever authoritative value this document has, it is fully consistent with the district court's interpretation of that statute. And that's explained by the fact sheet that if Brookens' claims were that a mixed union, such as the National AFGE, violated certain rights, then Lambda might apply. But this case involves the conduct of Local 12, not its mixed parent union. So I understood the court to look at what the Labor Department had decided and determined that the district court's conclusion was consistent with that, not contrary to it.
Well, I think once you, I think the bottom line is what actually did the Labor Department decide to do. And being a union member, we have union people who are very competent in the unions who do these cases all the time. So the issue is the Labor Department has taken the position to support and enhance its position in the Child versus Bremerton case. And they've developed regulations to support that. The government probably, somebody in the Labor Department or in the union in one of our union meetings could tell us what the authority is where the Department of Labor decides to expand and support a union member in this regard, so that it's not tying people up on these kind of issues. As you pointed out, I tried to be very careful and just cite to this court the authority that it has and cite to the regulations that I've identified. Now, in terms of the regulations that the Department of Labor put out regulations, they rescinded them and then they re-implemented them again to support the issues to support my position. So the Labor Department, the Office of Labor Management Standards has adopted my position.
All right.
It's not based on the decision from this court. I'm sorry, Your Honor.
Why don't we hear from counsel for appellees and from the federal appellees, and then we'll give you some time to respond.
Yes, Your Honor.
So, Mr. Harris.
May it please the court, Chad Harris for appellees Larhonda, Gamble, the American Federation of Government Employees, Local 12, in case number 215049, and Dino, Drudi, Frank Silverstein, and Gina Walton in case number 21-7020. Just to begin, just to address Mr. Brookens' points, or some of his points he raised, and I'll address more further. I want to be clear that this court, the precedent is clear by Wildberger and also Divin, which was issued prior to Wildberger in 1994, that a government only union, whether it's federal, state, or municipal, is not covered under the LMRDA. And in 1994, that was the case regarding WMATA and Metro employees, and that it is clear that the Department of Labor's regulations at the time that this complaint was filed and today are consistent with the plain text of the statute, which specifically excludes wholly government-only unions from coverage under the LMRDA.
Mr. Harris, if I can ask you, I mean, I think that seems absolutely clear with respect to something like Local 12, but what about the council, which is an intermediary organization, right? So the statute says a labor organization shall be deemed to be engaged in an industry affecting commerce if it is a conference, general committee, joint or system board, or joint council subordinate to a national or international labor organization. Oh, sorry, that's not the one I'm saying. The one, I'm sorry, I'm losing my place. But the statute discusses intermediary organizations, right? And so why isn't the council here an intermediary organization?
Even if the council, I mean, even if the council is an intermediate organization, it is still wholly and solely government-only union. There are no private sector employees in that, and there's no case that I'm aware of that has held that, except potentially the Ninth Circuit case, the Child versus Birmingham case, and that case is, frankly, is, in the union's opinion, is wrongly decided. And I will note that this court itself has questioned the reasoning in the Child versus Birmingham case in the Alabama Education Association versus Child, where this court acknowledged that most likely the education associations had a better reading of the statute than the Department of Labor and the at the time. And so, and that the regulation, I will add too that, you know, the regulation that Mr. Brookens is referencing, that regulation was rescinded. It's no longer in effect. And it hasn't been, it was rescinded in 2010, and it hasn't been in effect since then. And the current regulation is the one that has been in effect for 40 years prior to the one issued in 2002, which that intermediate labor organizations are not covered under the LMRDA.
But
Mr.
The Department of Labor has changed its position on that view across different administrations.
It's changed its position once, and currently before this court, the position is that an intermediate organization is not covered under the LMRDA. I will say too that this regulation is not under review before this court in terms of whether that proposed regulation is applicable. But I will also add that Mr. Brookens raised these arguments. He never raised the rescinded regulation from 2002 before the district court. And he never raised the proposed regulation from 2019 until his reply brief before this court. So we would assert that those issues have not been preserved for review by this court, and this court should not give any weight to them.
In short, though, your position would be that the determinative factor is not whether it is an intermediate level, but whether it is all government.
That is correct.
The council here is all government, right?
That is correct, sir. They are only government, Your Honor, they are only government unions and only government employees. And the statute is clear at 29 USC 42E that it defines employer, and it specifically excludes U.S. government or any state or political subdivision thereof. And it defines employees at 29 USC 402F as any individual employed by an employer. And so it is, the statute is clear that it doesn't apply, and there's no allegation or no dispute that Council 1 or Local 12 are not solely government employees. It's clear from the record that they are. And
Mr. Harris, has this court ever held clearly that an intermediate organization that is wholly that it wholly involves government employees is not covered by the LMRDA?
I'm not sure that this court has held that, or I have a specific case with that an intermediate organization is not covered. But I would add, before my time concludes, that this court has held that even if it was a mixed union, it has affirmed the district court's decision that a mixed union that is a federal sector union is not covered under the LMRDA because of the preemptive effect of the Civil Service Reform Act. And so that and the court most recently affirmed that in the Hudson v. AFGE case from 2019, where it held that it is that the preemption of the site is 2020 Westlaw 3035039 at 5, that even though AFGE, and in that case, AFG was sued, the national, and even though it is a mixed union, it said that because of the preemptive effect of the CSRA, it is not covered by the LMRDA. And so the union's appellees would also argue that because of the sui generis nature of federal sector unions, that they are not covered, whether it's the national level, the intermediate level, or the local level, because of the preemptive effect of the CSRA. And this court and the Supreme Court has repeatedly held, most recently in Trump versus AFGE, that the CSRA preempts employees' claims and union claims. And
But you don't need the preemption argument if we are satisfied that the all government nature of the intermediate precludes its coverage, right?
That is correct, Judge Sentelle. That is correct. And I see that my time has expired, but I'm happy to address any other questions that the court may have for me.
Thank you. So, the Assistant U.S. Attorney.
Good morning, Your Honors, and may it please the court. My name is Paul Serino. I represent the federal appellees in case number 21-5049. The remaining claim against the federal appellees on appeal is Mr. Brookens' argument that he's entitled to relief under the Labor Management Reporting and Disclosure Act. The district court correctly concluded that it did not have subject matter jurisdiction over this claim. And this is because Congress has not expressly waived the government's sovereign immunity with respect to claims under the statute. The Labor Management Reporting and Disclosure Act authorizes suits against labor organizations and not the employer, which is what the Department of Labor is here. So there's no basis for subject matter jurisdiction. Your Honors, the only other point is that Mr. Brookens' opening brief did not even address that the United States was subject to suit under the labor management statute, nor has Mr. Brookens responded to any of the federal appellees' arguments on the sovereign immunity issue. And so that point should be deemed to have been abandoned or otherwise forfeited. Mr. Brookens' reply states that his primary argument for jurisdiction is based on an interpretation of some proposed regulations, but he waived that argument by not raising it before the district court, as he admits in the reply brief. The bottom line, Your Honors, is that Mr. Brookens has not even argued, even during his presentation this morning, that the federal government is subject to suit under the Labor Management Reporting and Disclosure Act. So there's no reason to disturb the conclusion that the district court lacked subject matter jurisdiction over Mr. Brookens' claims against the federal appellees. And so the district court's judgment should be affirmed. And if the court has questions, if the court has no further questions, we'll rely on the arguments in our brief and ask that the court affirm the district court's judgment.
Thank you. All right. Mr. Brookens, do you want to take a few minutes to respond? Hi, Mr. Brookens, we cannot hear you. Are you on mute?
Okay.
Good.
Can you hear me now?
Yes.
Yes. Okay. The federal government is probably the main culprit in this whole operation. The federal
Well,
government has no.
But that's not the issue before us, is it? The question is.
No. The issue is my right to vote.
Did the
And my right to vote.
have jurisdiction over your complaint?
Yes. The statute provides any person who has I'm going to say a right to vote can raise the issue in federal court. And for me, the issue is my ability to vote. Now, the problem with the federal authorities is that they are assisting the union improperly by keeping me from attending union meetings. I can't go into the building. I can't go to meetings and these sort of things. My colleagues, who got cases at the Court of Appeals, Mr. Bastani and Ms. Wing, we can talk about these things and say, and the federal authority, because of the power of the security officer, which has no interest in our being able to talk and discuss and to look at these issues, is preventing me from coming into the buildings and talking with other people and to vote in union meetings. In-person voting meetings, unfortunately for COVID, I would be able to go to the meetings. They can vote things just like the union gave me the opportunity to vote in the 2018. I was certified to vote, and so I could come to the building and confer with people. And although this hearing has excluded other issues, but that's the main thing that's taking place. But for the fact that the federal authorities are are supporting the union, then I would be able to participate. I'd be able to run. The last election is over. I would be able to vote on the contract. I'd be able to talk to my colleagues about what our positions are, and that's all has been done. And this court, and that's this court, I'll be very careful to cite to this court the authorities that this court has cited. And of course, I don't think you would want to exclude or rule out the fact that the Labor Department took the same position against a similar counsel somewhere else because they on employees' rights. And so, and I did bring to attention, I'm an attorney from the Department of Labor. What's the status of the regulations? The Labor Department has obviously flipped over and adopted. The council said for 40 years they interpreted it this way. No, they've now moved to the Bremerton view of intermediate unions and local unions as being covered by this statute. And so there's no way around it.
All right, so I think we have your argument. Is there anything else?
No, Your Honor.
Thank you very much. We will take the two cases under advisement.
This honorable court is now adjourned until Tuesday, January 25th at 9:30 a.m.